Resuming debate, the honourable member for Perth Wellington.
Thank you very much, Madam Speaker, and I am indeed grateful for the opportunity to rise and participate in this debate today on the sub-amendment. I had the privilege to speak to the amendment, and so it's a great opportunity to pick up where I left off and to speak to this important sub-amendment that has been moved on this privileged motion. The fact is, though, we're still where we were. The Liberal government continues to refuse to release the documents that it has been ordered to produce by this very House. They do not wish to turn over the documents that will help to uncover clear corruption that has occurred at the Green Slush Fund. Sadly, corruption has benefited Liberal insiders during the entirety of these 9 years of this Liberal government. But, Madam Speaker, it's important, it's of vital importance, that no matter how hard Liberals try to push it away from Parliament, we must continue to pursue this issue. No matter how many times the member from Winnipeg North comes up with an attempt to shrug this off, we will continue to pursue this on behalf of all Canadians. And after all of these days of debate, the facts remain clear. First, taxpayer money was taken by conflicted board members of SDTC to benefit their own financial and business interests. And second, and equally as important for the integrity of this place, the House has still not been provided with the documents necessary, and there's been no indication of when or even if the money of these conflicted payments will ever be paid back. Now, Madam Speaker, in the time between when I spoke to the amendment to the time that I've spoken to the sub-amendment, more and somewhat interesting information has come to light. In my previous intervention on October 8th, I discussed the importance of Parliament being the grand inquest of the nation and the necessity of the power of this House to send for persons, papers, and records. Unfortunately, those in the Liberal cabinet and those in the bureaucracy seem to fail to understand this essential, constitutionally protected power of Parliament. This indifference was clearly on display last week at the Standing Committee on Public Accounts. On Wednesday, October 23rd, a high-ranking official, a deputy secretary, in fact, at the Privy Council office, one of the highest bureaucratic offices in this country, appeared. I asked the Deputy Secretary a very clear question. I said, do you accept that Parliament has the constitutional authority to call for documents without redactions? I did not get an answer. Instead, I got invalid excuses that ignored the key constitutional facts. The right of Parliament to send for documents is not limited by any policy or statute. As explained in Bosque and Gagnon, quote, no statute or practice diminishes the fullness of that power rooted in House privileges unless there is an explicit legal provision to that effect, or unless the House adopts a specific resolution limiting the power. The House has never set such a limit on its power to order the production of papers and records. Madam Speaker, it's quite frankly unacceptable that the Privy Council office and their senior officials have chosen to ignore that fact. And it's a simple fact that Parliament and its committees are the grand inquest of the nation. Our ability, constitutionally protected ability, is to call for the documents that we deem necessary, as this House did in June of this year when we ordered that the documents be provided to the law clerk, unredacted, to be provided to the Royal Canadian Mounted Police. Now, Madam Speaker, the power of this House to send for persons, papers, and records is an old power indeed. It is part of the very essence of our work within parliamentary democracy. Our Constitution since the founding of our country in 1867 has affirmed such a right. In fact, the British North America Act, now called the Constitution Act 1867, lays this privilege out in Section 18, and I quote from Section 18. The privileges, immunities, and powers to be held, enjoyed, and exercised by the Senate and by the House of Commons, and by the members thereof respectively, shall be such as are from time to time defined by Act of the Parliament of Canada, but so that any Act of the Parliament of Canada defining such privileges, immunities, and powers shall not confer any privileges, immunities, or powers exceeding those at the passing of such Act held, enjoyed, and exercised by the Commons, House of Parliament of the United Kingdom of Great Britain and Ireland, and by the members thereof." End quote.
Order, the Honourable Parliamentary Secretary of the Government House Leader.
Yes, Madam Speaker, it's just somewhat ironic. The member stood up on a point of order earlier today suggesting that I'm not allowed to read, and it would appear that he might actually be reading.
Again, it's not unusual for members to be reading something into the record verbatim. So on each side, I think that the issue earlier, I know that the honourable member raised that, but there was an issue on both sides that it was more about they were elaborating more than what was supposed to be the question of the Thursday question and the response. The honourable member for Perth Wellington.
Well, thank you very much, Madam Speaker. And just to reaffirm, I am quoting a passage from the Constitution itself, something that defines this very House and defines the very issue at play as well. And not to send a spoiler alert across the way, but I will have some more interesting quotations coming up later in my remarks, and I know the member from Winnipeg North will be very intrigued to hear some of those quotations on this important issue. After all, I believe that no member has contributed more to this very debate than the member from Winnipeg North. I believe it's north of 300 interventions he's had on this very debate, so I do congratulate him on his verbose contributions to the extensive debate that he is taking part in. So, Madam Speaker, let's get back to the important constitutionally protected issue at hand. Because, Madam Speaker, those privileges, immunities, and powers that were held by this House in 1867 and by the United Kingdom, its predecessor place, are continue to be here today and have some of their roots dating back centuries. In fact, some of the greatest protections that we have as parliamentarians originate in 1215 with the Magna Carta. And I'm going to give another quote for the member from Winnipeg North, and I quote from the United Kingdom Parliament that states, quote, "Magna Carta was issued in June 1215 and was the first document to put into writing the principle that the king and his government was not above the law. It sought to prevent the king from exploiting his power and place limits on royal authority by establishing law as a power in itself." Madam Speaker, how true that is. 800 years later, the Magna Carta still stands as the principle that no person, no king, no ruler is above the law. Now, I have but 20 minutes in this place to express my points, but I could go on at great length on the Magna Carta alone. But let's jump ahead a few centuries to 1688. And I know members will be intrigued with the discussion on the glorious revolution of 1688. And, Madam Speaker, I would note that the long-term impacts of the 1688 glorious revolution, a revolution that did not have bloodshed, I might add, are so important to where we are today and the rights that we have as parliamentarians, not for our own purposes, but on the behalf of the people that we have the honour of serving. Now, I want to quote from the Right Honourable John Dalberg Acton, one of the great UK parliamentarians, in his writing Lectures on Modern History. He wrote this about the Glorious Revolution, and I quote, "It is the greatest thing done by the English nation. It established the state upon a contract and set up the doctrine that a breach of contract forfeited the crown, the former in the English Convention, the latter in the Scottish. Parliament gave the Crown and gave it under conditions. Parliament became supreme in administration as well as in legislation. The King became its servant on good behavior, liable to dismissal for himself or his ministers. All this was not restitution, but inversion. Passive obedience had been the law of England. Conditional obedience and the right of resistance became the law. Authority was limited and regulated and controlled. The Whig theory of government was substituted for the Tory theory on the fundamental points of political science. The great achievement is that this was done without bloodshed, without vengeance, without exclusion of entire parties, with so little definiteness in point of doctrine that it could be accepted and the consequences could be left to work themselves out. And that's the end of that quote, Madam Speaker. But I point this out because our Constitution, our history of parliamentary government in Canada has a proud and a long and a respected history. This country, this system of government was built on those powers, where power was removed from the absolute crown and given to the people's representatives. The people's representatives who are here to express the common sense of the common people. Now, Madam Speaker, I'm sure that you will agree that parliamentary democracy ought to be protected, and it ought to be done with the protection of each and every member of this very House. No less a constitutional expert than the late Peter Hogg expounded on this in one of his seminal works, The Constitutional Law of Canada, 5th edition, at page 314. And I know the member from Winnipeg North is eager to hear this quotation from the great late Peter Hogg. And he said, and I quote at page 314 for those following along at home, "The Crown is, of course, subject to Parliament or legislature. So long as a legislative body acts within its power, it is free to make its laws applicable to the Crown or government, just as it is free to make its laws applicable to other legal persons within its jurisdictions. Any other conclusion would be inconsistent with the supremacy of the legislative branch of government. Indeed, it was settled in England as early as 1561 that the Crown was bound by any statute which applied to it. And this is one of the fundamental principles of the British Constitution that was received in the British North America Act." End quote. Madam Speaker, this reaffirms the very clear essence of this privileged debate. This House ordered the production of unredacted documents. It wasn't a, oh, if you have time, would you be so kind as to provide these documents? It was an order of this House, an order of this House's parliamentarians. Indeed, Madam Speaker, it comes down to the very essence of responsible government. And you would notice, Madam Speaker, in the sub-amendment that we're debating, we request the presence of certain experts, one being a senior official at the Privy Council office who had some interesting things to say on responsible government. But let's dig into a little deeper on the importance of responsible government. By the time the fathers of confederations were discussing plans to become a united Canada, it became clear that it was preferable to continue with the constitutional precedents inherited by the United Kingdom and not to adopt a system similar to what had been done in the United States. On February 6, 1865, the then Attorney General, soon to be the first Prime Minister, the Right Honourable Sir John A. Macdonald, rose in the House, the provincial province of Canada, to provide his thoughts on responsible government. And he said, and I quote, "In the Constitution, we propose to continue the system of responsible government, which has existed in this province since 1841 and which has long obtained in the mother country. This is a feature of our Constitution as we have it now and as we shall have it in the Federation." And that's end quote, Madam Speaker. And again, that is from page 33 of the debates, the third session of the 8th Provincial Parliament of the United Provinces of Canada. But, Madam Speaker, But, Madam Speaker, it goes on to explain, the first Prime Minister, that having Cabinet held responsible to the legislative branch was in an effort of to avoid giving too much power to the executive branch, as had been seen elsewhere, including south of the border. MacDonald went on to say, quote, "With us, the representative of the sovereign can only act on the advice of his ministers, those ministers being responsible to the people through Parliament." End quote. This is the essence of parliamentary democracy, that Parliament is supreme, and that Cabinet is responsible to Parliament. It cannot ignore, it cannot refuse an order of Parliament simply because a minister or even a Prime Minister may disagree with it. Now, Madam Speaker, where does this bring us today? Well, in normal cases, ministerial responsibility means that the minister ought to take responsibility for the challenges within their department. When the Leader of the Opposition made his initial question of privilege, he referenced a memorandum he had obtained from the Privy Council office at the beginning of this Parliament. That memorandum was written by a certain Paul McKinnon, and it states, "Public servants do not share in ministers' constitutional accountability to the Houses of Parliament, but support ministers in this accountability. The ultimate accountability for deciding what information to withhold from or release to parliamentarians resides with the responsible minister." So where is the accountability from the accountable minister? The Liberal government may believe that the rights and privileges of Parliament do not matter, but we will soon see if the responsibility of the minister responsible is there. It is time that the Prime Minister and his ministers account themselves to this Parliament. Now, I do want to recognize that the current minister wasn't the minister at the early days of the SDTC. So who was? Well, that minister was Navdeep Bains, who has since left Cabinet and politics. We have now twice attempted at the Standing Committee on Public Accounts to hear evidence from the former Liberal minister, Navdeep Bains. He may no longer be a Liberal minister, but he sure still talks like a Liberal minister, with empty statements that mean nothing and are intended to convey nothing. He refused to answer even basic questions at committee about dates and names, and he even refused to confirm where he was currently employed. This is yet again further evidence that the Liberals, even after their careers in politics are over, refuse to accept the responsibility and accountability for their actions. Which brings us to the sub-amendment before the House today. I must admit that I was slightly disappointed with the original ruling, in that I do not believe the best course of action is to refer this to the Standing Committee on Procedure and House Affairs. And I know the member opposite is wondering why I would have the concerns with the Procedure and House Affairs Committee, but that member knows very well about past Liberal scandals where lengthy filibusters occurred at the Procedure and House Affairs Committee, led by the members for Whitby or the member from Hull-Aylmer, who tried to prevent us from getting to the bottom of important Liberal scandals, like the We Charity prorogation scandal or the foreign interference scandals that we have seen. And that is why I think these amendments and sub-amendments are so important to strengthen the motion of the Speaker's ruling. The sub-amendment would ensure that Paul McKinnon, the former Deputy Secretary to Cabinet, and the Privacy Commissioner both appear as witnesses. Paul McKinnon, as explained by the Opposition House Leader on September 26th, is the official at Privy Council, the Council Office who authored the memo that I cited earlier. It is important that he explain before members of Parliament what he meant by the ultimate accountability for deciding what information to withhold from or release to parliamentarians resides with the responsible minister. In my view, this is me speaking, I'm ending the quotation. In my view, the ministers relevant to the June 10th motion have not been held accountable. The other witness that the sub-amendment proposes is the Privacy Commissioner. The Commissioner is obviously an expert in the matter of protecting documents and could also provide valuable insights to the rules and procedures for providing papers and records based on an order of the House of Commons versus based on what means such as an access to information request. And I might add as well that the Privacy Commissioner is a former officer of this Parliament as our law clerk, and so also has the added benefit of knowing and understanding the rights and privileges of this very House. This sub-amendment, if passed, would further strengthen the main amendment and ensure that we get the answers necessary. Madam Speaker, this debate could be over today if the Liberal government simply handed over the documents as ordered by this House so that they can be provided to the RCMP for them to do what they will, but to ensure that the accountability of this House is upheld. Thank you, Madam Speaker.
Questions and comments? The Honourable Parliamentary Secretary, the Government House Leader.
Yes, thank you, Madam Speaker. And, you know, it was interesting listening to the member talk about the Parliament in such a fashion, and he articulated. But one of the things that he forgot to talk about is that the only Prime Minister in the history of Canada, not only Canada, but the entire Commonwealth, to be held in contempt of Parliament was Stephen Harper. His current leader of the Conservative Party was his parliamentary secretary, Madam Speaker. Now, fast forward to today. Today we have the leader of the Conservative Party that feels that he doesn't need to get a security clearance. After all, his chief of staff has that security clearance. But he doesn't understand that he's saying to his chief of staff, if you tell me the names, it would be a criminal offense to do so. The leader of the Conservative Party doesn't understand that he's abusing the powers of the House. He is abusing the issue of foreign interference. Why won't the leader of the Conservative Party do the honourable thing, put the nation's interest ahead of his personal and party's interest, and get the security clearance, and while he's at it, stop abusing?
The Honourable Member for Perth Wellington.
Thank you very much, Madam Speaker. And as always, I thank the member from Winnipeg North for his question. I believe that was probably his 321st contribution to this debate. So I do wish him well on his continued interventions. But let's be very clear: the Prime Minister can and ought to release those names right now. We would call the Prime Minister into this House to release the names of any party. But let's take, you know, he wanted to take a little walk down.
Parliamentary Secretary.
Yes, the honourable member knows full well he cannot reference the presence or the absence of someone in the House.
That's not exact. That didn't happen at all.
He just asked for him to call the Prime Minister to come in the House.
So I'm sorry. There's debates going on now, so I will remind members that they're not to mention anyone's presence, whether a member is present or not in the House. Now, the Honourable Member Perth Wellington.
I would rephrase that to call the Prime Minister to rise in this House and make known the names of those individuals. But if the member from Winnipeg North wants to take a little walk down memory lane, let's talk about the corruption of this Liberal government. We have a Prime Minister who was twice convicted by the Ethics Commissioner for breaking the ethics law. The Prime Minister's parliamentary secretary, the member for Hull-Aylmer, was convicted of breaking the ethics law. Madam Speaker, the ethical challenges that are being faced by this Liberal government are the real issue and challenges at play here. So they can try to distract the Canadian people from the real issues, but the issue is, at the end of the day, the Canadian people will decide of who they wish to govern this country in a carbon tax election. And I say I'm ready any day to put the record of our Conservative Party up against any other party.